This is a 3-minute warning. We're going to get started in 1 minute. Welcome, everyone. We are pleased that you have joined us for today's webinar titled Post-Secure Rollovers of Inherited IRAs. The webinar will last approximately 20 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Linus Sugis. Linus is the president of Advanced Underwriting Consultants. He and his team answer tax and technical questions posed by producers every day. Linus also spent 14 years working in the home office of a life insurance company in various roles. He also started, ran, and sold an estate planning law practice in the Nashville area. Linus will draw on his legal and life insurance experience during today's webinar, and here he is.
Thank you very much, Amber, and welcome everyone. I'd like to thank you for joining us today for post-secure rollovers of inherited IRAs. Before we delve into that topic, let's decide on what it is that we're going to talk about next month in October. We have these free webinars the first Wednesday of every month. And next month, your choices will be Britney Spears teaches about conservatorships, captive insurance companies get a win, or HSAs in a nutshell. I'm going to open the poll in a second and ask you to go ahead and vote for one of the choices. So if you would, make your vote for what it is you want to hear. I'll give you about 15 seconds and then we'll move on to today's content. If you haven't voted, go ahead and take a second and get your vote in. All right, we're going to go ahead and close the poll, and Next month, we're going to hear Britney Spears teaching us about conservatorships. Thank you for voting, and appreciate that. Please go ahead and mark your calendars. Make sure that you've got Wednesday, October 6, 2021 at this time, 11 a.m. Central, marked on your calendars. So let's go ahead and talk about post-secure rollovers of inherited IRAs. Today's webinar will probably be a little shorter and more direct than usual. We're going to review quickly some of the stretch rules with regard to inherited IRAs or inherited qualified accounts after the Secure Act. We'll quickly go over the spouse stretch rules. We'll talk about the regular non-spouse inherited IRA stretch rules. And then we'll talk specifically about a private letter ruling from earlier this year and what message that private letter ruling gives us that's relevant to this conversation. So there are two choices after the Secure Act was passed for spousal, inherited IRA, or inherited qualified account stretch. Choice number one is to treat the account as inherited, and option two was to elect spousal continuation. It is to elect spousal continuation either in place or by rollover to a new carrier. And so let's talk first of all about option one, treating the account as inherited. What's involved with that? Well, if a spouse inherits an IRA, RMDs are due for years beginning after the deceased spouse would have turned 72. And they're calculated by referring to the single life expectancy table, not the uniform lifetime table, the single life expectancy table, using the surviving spouse's actual age in that year. And so the table, has larger factors than the uniform lifetime expectancy table. And RMDs are not necessarily due immediately. It depends on the age of the deceased spouse. They're due beginning with the year the deceased spouse would have turned 72. And RMDs must be taken every year from an inherited account if this choice is made. When would someone make this choice? It makes a lot of sense for a surviving spouse to make the choice to treat the account as inherited if the surviving spouse is younger than age 59 and a half and needs money. And the reason that it makes a lot of sense is that distributions from an inherited IRA made to the surviving spouse are not subject to the extra 10% penalty tax, even if the surviving spouse is younger than age 59 and a half. Now, the account has to be inherited for that special treatment, and that's why it makes some sense to think about leaving the account as inherited for the surviving spouse. It also may make sense for the surviving spouse to elect to treat the account as inherited if the deceased spouse was much younger and died prior to age 72. RMDs can be delayed until the year the deceased spouse would have turned 72. And so if the deceased spouse was much younger, RMDs in a lot of cases can be put off longer from an inherited account than if the surviving spouse chose the second option. And what's the second option? The second option is to elect spousal continuation. And that can be done either at the carrier, at the IRA custodian, where the money is usually, or by rollover to a new custodian. An inherited account gets rolled over into the spouse's own IRA. That is a valid way to elect spousal continuation. You can't do 60-day rollover and leave the account as an inherited IRA, but you can do 60-day rollover and transform the account if surviving spouse is the beneficiary into the spouse's own IRA. And when does spousal continuation make sense? Well, probably in most cases. Usually the surviving spouse wants to consolidate IRAs. This would allow her to do so. She could mix the inherited IRA money into her own IRA money it can all be in one account. There's just one account to keep track of. That's perfectly allowable. And another reason for surviving spouse to elect spousal continuation is that she gets the use of a better table. So what do I mean by that? If the surviving spouse wants to take smaller RMDs, even though she's already 72, she gets to use the uniform life expectancy table, not the single life expectancy table. And that allows her to take smaller RMDs because the factors are lower, meaning that she's got more flexibility in deciding how much money to take out of the IRA account once minimum distributions must start. So there you go. If we've got a non-spouse beneficiary of an IRA, post-secure, we've got really one option, and that is 10-year liquidation. That's for most kinds of non-spouse beneficiaries. The exceptions are if we've got an eligible designated beneficiary, we can still potentially stretch based on life expectancy for a while or perhaps permanently, depending on the circumstances. So we do still have some echoes of pre-secure rules for a non-spouse beneficiary under those circumstances. Who's an eligible designated beneficiary? It's the minor child of the account owner. It's somebody who's disabled, someone who's disabled. They're the common ones. Those are the common ways that someone can be an eligible designated beneficiary. Also, we don't necessarily get 10-year liquidation if the beneficiary is a trust or an estate. In a lot of those cases, we may get 5-year liquidation rules or something else, and we'll talk about that in a little bit more detail in a second. So that's really the main option for a non-spouse beneficiary. We get 10-year liquidation. And one important thing that we get asked about here at Advanced Underwriting Consultants quite a bit is that it's not possible to do a 60-day rollover of money in a non-spouse inherited IRA account. Can't be done into the beneficiary's own IRA, can't be done into an inherited IRA. A 60-day rollover, an indirect rollover, is not permitted. It's been the case where it's not been permitted for a long time. A lot of people get confused about that because with a spouse inherited IRA, an indirect rollover is allowed into the spouse's own IRA. And so the 60-day procedure is available if the spouse is the beneficiary, but where we've got a non-spouse beneficiary, it's been the rule for a long time that no indirect rollovers are possible. So we've got some ambiguities in the Secure Act where we've got a trust as the beneficiary. The Secure Act didn't address many of the issues related to trusts as beneficiaries, so we're porting over some of the pre-Secure Act rules about trust beneficiaries and trying to interpret them as they might apply with regard to the Secure Act. And one of the rules is that if surviving spouse is the sole beneficiary of a trust, in a lot of cases, we may be able to pull off spousal continuation through the indirect rollover method by following a very specific procedure. And that is that the trust liquidates the inherited IRA, the trust as beneficiary liquidates the inherited IRA, it turns around and gives the surviving spouse the money within a short period of time, and the surviving spouse, within 60 days of the trust liquidating the inherited IRA, deposits that money into the spouse's own IRA. And that's how spousal continuation can be elected indirectly, where a trust is the beneficiary through indirect rollover. But there's some private letter rulings that support that, but it's all the stars have to line up for that to be true. And remember what I said earlier, surviving spouse is the only one, the only beneficiary of an inherited IRA that is allowed 60-day rollover, and the procedure is available. The special 60-day procedure where the trust is the beneficiary is available only if the surviving spouse really has a lot of control over that trust. Where we have a surviving spouse is not the primary beneficiary of a trust, and the trust itself is the beneficiary of the IRA, we believe that look-through trust status is going to be needed in order for 10-year liquidation rather than 5-year liquidation to be available on the trust. That's our best guess, and that's that's the way that it is. Do we have the ability to do an indirect rollover of an inherited IRA that is inherited by a look-through trust? The answer is that we've been almost 100% sure the answer was no, and that's really the punchline for today's webinar. Somebody asked the IRS for a private letter ruling asking for an indirect rollover of a trust beneficiary IRA. And so under the facts of this particular case, when the original account owner died, the IRA became an inherited IRA for the beneficiary of the trust. Okay, so trust beneficiary, trust controls the inherited IRA. And so the custodian of this IRA, under the facts of this private letter ruling, advised the trustee of the trust that they couldn't trade stocks in the IRA, and that the assets of the inherited IRA would have to be transferred elsewhere in order for the trustee to be able to trade stocks. Well, the trustee, at least according to this private letter ruling, based on the advice in part of the custodian, the trustee transferred all of the inherited IRA's assets into what's essentially a checking account held by the custodian for the benefit of the trust, right? So it's a trust checking account that now has the money. So the trust has liquidated the money. And the trustee, apparently realizing that that's a problem, eventually decided to try to deposit the money back into the inherited IRA, and they asked the IRS for permission to do that, essentially asking the IRS, can we do an indirect rollover? Well, the trust beneficiaries are not the surviving spouse of the original account owner. They are all the kids of the account owner. So with all of those facts in place, the fact that we're past the 60-day deadline, and the fact that the taxpayer trust was trying to do an indirect rollover of an inherited IRA payable to a non-spouse beneficiary, or payable to a trust for the benefit of non-spouse beneficiaries, all the facts were lined up against the taxpayer, and it's hardly a surprise that the IRS said, no, you can't do an indirect rollover of the money in this inherited IRA account, and therefore you can't do what it is that you're asking us for permission to do, trustee. You have liquidated the inherited IRA, and you have recognized the income tax result associated with that account, and there are no fixes that are available to you. You have a tax result, and that is the end. And I suppose from my perspective, that's reassuring. The IRS confirmed what we've been telling people for a long time, and that is that if you've got a non-spouse beneficiary of an inherited IRA or an inherited account, qualified account, you can't do an indirect rollover. You can't do a 60-day rollover. So what are the key takeaways from today's session? Well, I think first of all, it's important to remember that spousal stretch rules are really mostly the same in this post-secure world as they were prior to this Cure Act. We still got spousal lifetime stretch as an option. We still have spousal continuation as an option. For our non-spouse beneficiaries, 10-year liquidation is the general rule. even though the IRS gave us some ambiguity earlier this year over whether RMDs were due along the way for a non-spouse beneficiary, it's pretty clear that it's 10-year liquidation. That is the rule, and no RMDs are needed along the way. It's just that the inherited account must be liquidated on or before the 10th anniversary of the original account owner's death. And I think the other thing that one other thing to remember is that if we've got a look-through trust, it probably gets 10-year liquidation, although we may get some clarification from the IRS over time. And then finally, the key message from the private letter ruling is that non-spouse beneficiaries do not have the ability to do 60-day rollover of inherited qualified accounts. It's an important message, important thing to let our clients know if they are non-spouse beneficiaries. If they decide to take the money, it is game over. They are going to recognize the income tax result associated with liquidating the inherited account. I'd like to thank you again for joining us on our webinar today, and I will turn the program back over to Amber to close us out. Amber?
Thank you, and thank you all for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, which is October 6th at this same time. Next month's webinar will be titled Britney Spears Teaches About Conservatorships. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again, and best wishes for continued success.